Arbitration is often praised as a faster, more efficient, and flexible way of resolving disputes. However, one feature that people do not really talk about is how relatively expensive it can be. From arbitrators' fees, down to institutional cost, down to the cost of securing expert witnesses, even to counsel fees. The financial burden of pursuing an arbitration case can be overwhelming. In fact, for many businesses, especially when facing well-resourced opponents, the cost alone can discourage even the strongest claims. So what then is the solution? Third-party funding. Third-party funding is an innovative financial procedure introduced by the Arbitration and Mediation Act 2023. By this procedure, a third party undertakes the financial burden of a party's arbitration case, usually the claimant, in exchange for a portion of the arbitral award if the claim succeeds. This procedure relieves a party of the financial burden it would have been exposed to in pursuing an arbitration case.
Where third-party funding agreement is made, the law mandates the claimant or the party exploring funding to notify the parties, the arbitrator, and the arbitral institution of the existence of a funding on or before the commencement of the arbitration proceeding. Where the arbitration proceeding has already commenced, the law also mandates the claimant or the party exploring funding to notify the parties and the arbitrator of the existence of a third-party funding agreement at the point this agreement is executed. Notably, third-party funding is not only explored within the confines of an arbitration proceeding. Third-party funding can also be explored for arbitration-related claims before the court in Nigeria. For instance, in an action for recognition and enforcement of awards. As Stren Blan Partners, we advise our clients on the use of third-party funding for their arbitration-related claims before the court and before arbitral tribunals.